Welcome to DX Group GDPR Data Privacy Overview, version 1.0. In this session, we will cover the following. What is GDPR? The information GDPR applies to, information owner rights, key points, what's new in GDPR, and things you must do. So what is GDPR? Well, GDPR stands for General Data Protection Regulation, and it is a new EU-UK privacy law in enforcement from the 25th of May 2018. And this affects all DX divisions. GDPR provides an enhanced set of rules which govern how organisations must manage personal data and imposes limits on the use of this information in all forms, and that's called processing. And GDPR provides EU-UK citizens with more control on how their information can be used and provides enhanced access rights. It imposes high fines of up to £17 million or 4% of global revenue, whichever is higher, and that's per breach. So what information does GDPR apply to? So here is the legal bit. The GDPR official definition states that personal data is in scope and defines personal data as any information relating to an identifiable person who can be directly or indirectly identified, in particular by reference to an identifier. This broad statement is in essence says that any information on its own or combined which can identify an individual, even indirectly, is covered by this law. So think about yourself as an individual, for example. There are many ways to uniquely identify you, including home and business related information. Yes, business contacts can also be considered as personal data, as it identifies an individual at a company address. The full scope of information included is wide, and there are some not so obvious inclusions. So, email, content of email, or the email address itself. Think about what's on an email signature or information contained in an attachment. Geolocation is now included. Electronic records in various systems, files, Excel and Office documents. CCTV is also covered. Any video source that points at public is covered. Audio recordings. Contact information, address, telephone number, etc. Paper records. And any sensitive personal information, e.g. medical information. This is a special category and is a special way of managing this information. So information owners now have additional rights. So what are they? So these are quite complex. Organisations have to respond to access requests within 1 month. These are known as SARs, and all are provided free of charge. Individuals have the right to be informed, which encompasses an organisation's obligation to provide fair processing information, which is typically provided via one or more privacy notices. It emphasises the need for transparency over how organisations use personal data. Right of access. Individuals have the right to access their personal data and supplementary information. The right of access allows individuals to be aware of and verify the lawfulness of processing. Right to rectification. The GDPR gives individuals the right to have personal data rectified. Personal data can be rectified if it is inaccurate or incomplete. Right to erasure. The right to erasure is also known as the right to be forgotten sometimes. The broad principle underpinning this right is to enable an individual to request the deletion or removal of personal data where there is no compelling reason for its continued processing. Note that under UK law, it is also an offence to delete a subject's data to avoid highlighting processing anomalies. Right to restrict processing. Individuals have a right to block or suppress processing of personal data. When processing is restricted, you are permitted to store the personal data but not further process it. You can retain enough information about the individual to ensure that the restriction is respected in the future. Right to data portability. The right to data portability allows individuals to obtain and reuse their personal data for their own purposes across different services. It allows them to move, copy, or transfer personal data easily from one IT environment to another in a safe and secure way, without hindrance to usability. Some organisations in the UK already offer data portability through the MI data and similar initiatives which allow individuals to view, access, and use their personal consumption and transaction data in a way that is portable and safe. For example, it enables consumers to take advantage of applications and services which can use this data to find them a better deal or just help them understand their spending habits. Right to object. Individuals have the right to object to processing based on legitimate interests or the performance of a task in the public interest or exercise of official authority. And this includes profiling, direct marketing, including profiling again, and processing for the purpose of scientific or historical research and statistics. Rights related to automated decision making, including profiling. The GDPR has provisions on automated individual decision making. That's making a decision solely by automated means without any human involvement. And profiling. That's automated processing of personal data to evaluate certain things about an individual. Profiling can be part of an automated decision making process. Next, I will talk about the key points around GDPR. Information retention. Keeping copies of personal information is limited to lawful use. We can no longer keep emails, paper records, data, spreadsheets, and documents which contain personal data for as long as we want. See the DX data retention policy for details. Unlawful access to information. DX must ensure we protect this information, technically and operationally, and limit who can access this information. This will require new ways of working by all in DX. Supplier management. DX is required to ensure all suppliers and partners who have access to DX information also comply with GDPR contractually and ongoing by good supplier management. We have to check all supplier agreements are GDPR compliant before we use them. Communication. DX has to provide the information owners with details of what information DX will hold and what we use it for, how long we keep it, and what rights the information owner has and how to contact DX to exercise their rights. This is done via a privacy notice on www.dx.co.uk. www.dxdelivery.com. Subject Access Requests or SARs. Information owners can contact DX to exercise their rights to object, delete, withdraw consent, etc. And DX must respond to the request within 30 days or we will be in breach of GDPR. Read our privacy policy on www.dxdelivery.com for details. Records of processing. DX must maintain a central record of all information which we hold and process and keep it up to date. Privacy by design. DX must ensure that any process or system which manages personal data are implemented using a privacy by design principle. GDPR breach assessment and notification. DX has 72 hours to investigate and notify the authorities of any information breach which would impact the rights and freedoms of an individual. If we fail to do so, we could be liable for a fine up to £10 million or 2% of global revenue, whichever is higher. And that's just for the failure to meet the notification obligations. And the fines are much higher, as stated before, up to £17 million fine or 4% of global turnover, whichever is higher. So things you must do. So queries and requests. Direct GDPR and information requests to DP Controller at the dx.co.uk. Point customers who want to know more about how we manage their information to our privacy notice, which is located on www.dxdelivery.com. Information management. Delete data or shred paper documents which fall outside the DX data retention policy retention limits. No matter where the information is stored, we cannot keep it. Read and follow the DX information classification and exchange policy and avoid exporting any personal information to Excel or other forms when not needed. Do not share information with third parties without approval, even if you have done so before, as we may not have the right to do so anymore. Policies and procedures. Read and follow DX policies and follow the processes. Think about privacy in all aspects of your job. If you are unsure about a process, then ask your line manager for assistance. Incident and breach reporting. Report possible and actual breaches as soon as possible to Information Security Incidents at the dx.co.uk. You can also contact the service desk, as we have 72 hours to notify the ICO, which stands for the Information Commissioner, so that time is short. For example, lost laptops, lost handhelds, information sent to the wrong person, malware, or a suspicious person in a DX site could be considered as a possible breach. And lastly, think privacy. Consider privacy and security when accessing or managing all forms of information.